In this explainer, we are not going to treat the Civil Procedure Code as a mere academic text. Instead, we'll approach it as what it is in practice, an essential roadmap for the courtroom. We will trace the entire life cycle of a civil suit, focusing on the practical application and the strategic thinking you need to master at every single stage. So here's how we'll structure this. We are going to follow the logical progression of a civil suit, right from its institution. We'll move through pleadings, the trial itself, the judgment, and then finally execution and appeals. Each stage will be directly mapped to the governing orders in the CPC. All right, let's begin with the institution of the suit. At this foundational stage, procedural precision isn't just advisable, it's absolutely mandatory for the very survival of your client's action. Before we proceed, it's critical to understand the code's architecture. The sections of the CPC provide the substantive law. These are the core principles. But the procedural mechanics, the how-to of litigation, are all detailed in the orders and rules of the first schedule. An effective practitioner must have a complete command of both. Now, the initiation of a suit follows a strict and frankly non-negotiable sequence. First, there's the meticulous drafting of the plaint, which is governed by Order 7. This is followed by the formal filing, or the institution, of the suit under Order 4. And finally, the court issues summons to the defendant, a critical step governed by Order 5 to ensure the principles of natural justice are met. A defect in any one of these stages can be grounds for dismissal or cause significant, costly delays. We now advance to the pleadings. These written submissions, the plaint on one side and the written statement on the other, form the very bedrock upon which your entire case is constructed. Everything that follows will be decided based on what's in these documents. The plaint under Order 7 has to articulate a clear and complete cause of action. It must contain only material facts, not law, and certainly not your evidence, and it must seek specific identifiable relief. On the other hand, the written statement under Order 8 is the defendant's formal response. It requires a specific pairwise denial of the plaint's allegations. It's also the correct and only stage to introduce any set-off or counterclaim, and to raise all your preliminary objections. This brings us to a critical question for every single advocate. Where do we see lawyers most often make damaging, sometimes irreversible, errors during the pleading stage? Well, these errors are unfortunately frequent, and they can be fatal to a case. If you fail to plead a material fact, you may be barred from leading evidence on it later. If you plead evidence instead of facts, you've made a fundamental error. Vague denials are treated as admissions. An improper verification can render the entire pleading defective. And, most critically, a plaint that discloses no cause of action is liable for summary rejection under Order 7, Rule 11. Okay, once the pleadings are complete, the court proceeds to the next critical phase, the framing of issues. This is where the dispute is distilled and the definitive agenda for the trial is set. Under Order 14, the court crystallizes the dispute into specific questions. These are the issues. And it's vital to understand this. The issues are framed directly from your pleadings. Imprecise drafting in your plaint or written statement will lead to vague or disadvantageous issues, essentially defining the battleground to your client's detriment from the outset. The trial itself is simply the process of proving or disproving these framed issues. This is conducted through the examination of witnesses, a procedure meticulously governed by Order 18, and the production and marking of documentary evidence under Order 13. The entire evidentiary phase is anchored to those issues framed by the court. Following the conclusion of the trial, the court delivers its decision. This decision is formally expressed and then executed through two distinct instruments, the judgment and the decree. Now, let's be very precise about our terminology here. A decree is the formal expression of an adjudication that conclusively determines the rights of the parties concerning the matters in controversy. This isn't just the court's reasoning, it is the court's final, binding, and enforceable command. A frequent point of confusion is the distinction between a judgment and a decree. Under Order 20, the judgment contains the court's reasoning, its analysis of the evidence, and the legal principles it applied. The decree, however, is the concise, operative part of that decision. It's the final order that is actually capable of being enforced. Obtaining a favorable decree is really only half the battle. The next stages, execution and appeals, are where those rights are either finally realized or, if you're on the other side, successfully challenged. Execution is the machinery for enforcing the court's decree. It's governed by Order 21, which is the longest and one of the most complex orders in the entire CPC. This process is so intricate that it's often considered a separate proceeding altogether. A decree holder must navigate this very carefully to actually reap the fruits of their litigation. Now, for the aggrieved party, the CPC provides several remedies. A first appeal against an original decree as filed under Order 41, a second appeal, which lies only on a substantial question of law against an appellate decree, falls under Order 42, appeals from specific non-decretal orders are governed by Order 43, and finally, a party may seek a review of a decision from the very same court under Order 47, but this is only available on very limited and specific grounds. This brings us to a fundamental principle of civil practice. You must never forget that procedural law is the master, not the servant, of justice. A thorough practical command of the CPC is simply non-negotiable for any serious practitioner. So let's conclude with the key strategic takeaways. First, draft your pleadings with absolute precision. They are the bedrock of your entire case. Second, you have to anticipate judicial scrutiny at every stage, from the filing of the plaint under Order 7 to the complexities of execution under Order 21. Master the distinction between a judgment and a decree. Know your post-decree remedies inside and out. And finally, treat procedural correctness not as a burden, but as a strategic weapon in your arsenal. We have now traced the entire life cycle of a suit. This leads me to a final strategic question for your own professional consideration. Which of these procedural stages, in your assessment, offers the greatest strategic leverage for a diligent advocate? The answer often separates the merely proficient practitioner from the truly masterful one.